this fan off real quick. God damn it, why does this goddamn thing always gotta be problematic with me? Every time I try to turn this damn thing on. I hate when I gotta pick all that shit up later. Whatever. Alright, I'll pick that up later. Anyway. Alright. Where did I That's it there. As I said, let's put that book. There it is. Alright. Hell of an intro, isn't it, right? Alright, but anyway, hello ladies and gentlemen, Force Wolver here, welcome back to another reading live stream. As you can tell, today is the 4th of July, so happy 4th of July to anybody, any American watching this. And yes, I am a fellow American, so I can for sure do this. So I decided, I already planned this in advance, some time ago. I already planned this whole idea in advance, but with a certain thing that happened recently, probably may have heard of it, probably didn't. You'll know about it when I get done with reading a certain thing in this book. But yeah, I'm going to be reading this book, and like I said on a community post, I do have a bit of a question if, in the event I'm done reading a certain part of this book, but we'll get to that when we get to it. In any event, we're going to go ahead and read the Constitution of the United States of America, plus the Declaration of Independence, and the Bill of Rights. So without further ado, let's get started. But first, the fact that I've had this book came out in 2014. So this book in itself is 10 years old, but whatever. Anyway, let's read the introduction first. That's what we're going to go ahead and Introduction. On July 4th, 1776, in the midst of the Revolutionary War, the 13 original colonies of the United States ratified a document that would later be known as the Declaration of Independence. In it, the Continental Congress and the people it represented declared they were no longer under the rule of Great Britain and were now the United States of America. This newly formed country had one of its most respected citizens write the Declaration, 33-year-old Virginia delegate Thomas Jefferson. Though he was one of the youngest members of the Congress, his fellow members of the Declaration Committee quickly chose him to draft this important document. Okay, vehicle in the background. You. Anyway. When Jefferson suggested John Adams write instead, Adams gave him the reasons he was the best choice. Quote, "Reason first, you are a Virginian, and a Virginian ought to appear at the head of this business. Reason second, I am obnoxious, suspected, and unpopular. You are very much otherwise. Reason third, you can write 10 times better than I can." Jefferson spent 2.5 weeks writing and rewriting what would become the defining treatise of his legacy. His words still resonate with Americans and people all over the world who believe in an individual's right to, quote, "life, liberty, and the pursuit of happiness." Soon after the Declaration of Independence was signed, a Second Continental Congress convened to draft the Articles of Confederation, which dealt with matters of war and state sovereignty. But after the Revolutionary War, a document was needed to form a stronger union, and to provide a permanent guarantee of the political liberties achieved during the Revolution. The delegates who convened at the Federal Convention in Philadelphia on May 25, 1787, quickly rejected the idea of revising the Articles of Confederation and agreed to construct a new framework for a national government. Throughout the next 4 months, they debated the proper form such a government should take, led by their elected president, George Washington. Few of the delegates questioned the need to establish a more vigorous government to preside over the Union of States. It was recognized by most in the land that the Articles of Confederation failed to provide the federal government with the authority to raise revenue, regulate commerce, or enforce treaties. The challenging task before the delegates was to create a government that could encompass the 13 existing states and accommodate the anticipated expansion to the West. The resulting document's distribution of authority between legislative, executive, and judicial branches was a boldly original attempt to create a robust central government which while preserving the independence of individual states and their citizens. The longest debate of the convention centered on representation in the Congress. The division between the representatives from the smaller states, which thought all states should have equal representation, and the larger states, which proposed representation proportional to population, threatened to bring the proceedings to a halt. What the heck? Hold on. Hey! What are you barking at? Yeah, I don't know what my dog was barking at, but alright. Hey Leah, how you doing today? Happy 4th of July to you as well. Where was I? Oh yes, I was actually able to finish that paragraph before my dog barked in. The longest debate of the convention centered on representation in the Congress. The division between the representatives from the smaller states, which thought all states should have equal representation, and the larger states, which proposed representation proportional to population, threatened to bring the proceedings to a halt. Over several weeks, the delegates developed a complicated compromise that provided for equal representation of the states in a Senate elected by state legislatures and a House of Representatives elected by the popular vote. But perhaps more contentious was an undercurrent of conflict during the debates between the slave states and the free states. The Constitution ultimately granted protection to the institution of slavery, even though it never overtly mentions the word slavery. The strained attempt at compromise would remain unresolved until 1865, when the 13th Amendment, abolishing slavery, was passed. The need for amendments to the Constitution had come along much earlier than that, however. In fact, the debates that ensued in state senates while the Constitution was being ratified by each state made clear the need for additions to the basic framework drafted in Philadelphia. Beginning with Massachusetts, a number of state conventions ratified the Constitution with the request that the text be written to protect certain liberties at the core of American traditions. James Madison, a longtime friend and colleague of Declaration writer Thomas Jefferson, was by then a member of the new United States House of Representatives and set about making changes to the Constitution to guarantee the freedoms that Americans hold dear. But several of his fellow representatives objected, especially well-respected Connecticut Representative Roger Sherman, who said that Congress had no authority to change the Constitution directly. So Madison drafted a list of amendments that would come to be known as the Bill of Rights. These amendments, which were ratified in 1791, and those that have followed have enabled the Constitution to adapt to changing constitutions in American society all while keeping the founder's basic outline of national government intact. The documents in this collection, the Declaration of Independence and the Constitution of the United States of America, are a monument to the combined spirit of all Americans as well as a testament to the extraordinary minds of our founding fathers who put them on paper. A full analytical index of the original Constitution and all of its ratified amendments follows. And no, we're not going to read that because then we'd be here all frickin' day reading it. I'm only reading the Constitution, the Declaration, the Constitution, and the Bill of Rights that follow it. Alright, just so we're all clear. But first, the Declaration of Independence. In Congress, July 4th, 1776. The unanimous declaration of the 13 United States of America. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are Hey! I already looked out there, there's nobody out there, so quit your barking! You're interrupting a thing going on here, man. Calm down. I love my dog, but yeah, he's interrupting the show. Anyway. Where were we? Yes. I'll just restart from the beginning, because, yeah. Hey, Daniel Barry, how you doing today? Happy 4th of July to you as well. I'm going to restart from the paragraph that I was on. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles, and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shown that mankind are more disposed to suffer, while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, invices a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Such has been the patient sufferance of these What the heck are you barking at? Why are you even barking in the bathroom? There's nobody even in the bathroom. And they wouldn't be able to fit that closet over there. So what are you barking at? If you got nothing to bark about, then don't bark. That's gonna be a recurring theme today, isn't it? Where my dog's gonna be barking every so often. Anyway, I'll start with the sentence that I was on before my dog barked at the end. Yeah, I was right. Let's see here, manage. Yeah, I think I was actually starting the new sentence when he barked, so we'll just start there. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain, I believe it was George III, is a history of repeated injuries and usurpations, all having indirect object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. He has refused his assent to laws, the most wholesome and necessary for the public good. He has forbidden his governments to pass laws of immediate and present importance, unless suspended in their operation till his assent should be obtained, and when so suspended, he has utterly neglected to attend to them. He has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the right of representation in their legislature, a right inestimable to them and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records, for their sole purpose of fatiguing them into compliance with his measures. He has dissolved representative houses repeatedly, for opposing, with many firmness, his invasions on the rights of the people. He has refused for a long time, after such dissolutions, to cause others to be elected, whereby the legislative powers, incapable of annihilation, have returned to the people at large for their exercise, the state remaining, in the meantime, exposed to all the dangers of invasions from without and convulsions within. He has endeavored to prevent the population of these states. For that purpose, obstructing the laws for his naturalization of foreigners, refusing to pass others to encourage their migration hither, and raising the conditions of new appropriations of lands. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. He has erected a multitude of new offices, and sent hither swarms of officers to harass our people and eat out their substance. He has kept among us, in times of peace, standing armies without the consent of our legislatures. He has affected to render the military independent of and superior to the civil power. He has combined with others to subject us to a jurisdiction foreign to our constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for quartering large bodies of armed troops among us, for protecting them by a mock trial, for punishment for any murders which they should commit on the inhabitants of these states, for cutting off our trade with all parts of the world, for imposing taxes on us without our consent, for depriving us, in many cases, of the benefits of trial by jury, for transporting us beyond seas to be tried for pretended offenses, for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government, for suspending our own legislatures, and declaring themselves invested with power to legislate for us in all cases whatsoever. He has abdicated government here by declaring us out of his protection and waging war against us. He has plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people. He is at this time transporting large armies of foreign mercenaries to complete the works of death, desolation, and tyranny already begun with circumstances of cruelty and perfidy scarcely paralleled in the most barbarous ages, and totally unworthy the head of a civilized nation. He has constrained our fellow citizens, taken captive on the high seas, to bear arms against their country, to become the executioners of their friends and brethren, or to fall themselves by their hands. He has incited domestic insurrection among us, and has endeavored to bring on the inhabitants of our frontiers, the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. Please bear in mind that this was in 1776. Native Americans were not really looked very well too fondly at this point. Yeah, so bear that in mind. They were treated with some racism in their own right, alongside how the African Americans were treated in the South. Like shit, pretty much. Anyway, in every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. Nor have we been wanting in our attentions to our British brethren. We have warned them from time to time of attempts by the legislature to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our immigration and settlement here. We have appealed to their native justice and magnanimity. We have conjured them, by the ties of our common kindred, to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They too have been deaf to the voice of justice and consanguinity. Yeah, that's how it is, I guess. Anyway, we must therefore acquiesce in the necessity which denounces our separation, and hold them as we hold the rest of mankind, enemies in war, in peace, friends. We, therefore, the representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name and by the authority of the good people of these colonies, solemnly publish and declare that these united colonies are, and of right ought to be, free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of the Great Britain is, and ought to be, totally dissolved, and that, as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states may of right do. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. Signed by John Hancock, President. Georgia, Button Gwinnett, Lyman Hall, George Walton. From South Carolina, Edward Rutledge, Thomas Hayward Jr., Thomas Lynch Jr., Arthur Middleton. North Carolina, from North Carolina, William Hooper, Joseph Hurwitz, John Penn. From Maryland, Samuel Chase, William Paca, Thomas Stone, Charles Carroll of Carrollton. From Virginia, George Wise, Richard Henry Lee, Thomas Jefferson, Benjamin Harrison, Thomas Nelson Jr., Francis Lightfoot Lee, Carter Braxton. From Pennsylvania, Robert Morris, Benjamin Rush, Benjamin Franklin, John Morton, George Clymer, James Smith, George Taylor, James Wilson, George Ross. From Delaware, Caesar Rodney, George Reed, Thomas Mickian. From New York, William Floyd, Philip Livingston, Francis Lewis, Lewis Morris. From New Jersey, Richard Stockton, John Witherspoon, Francis Hopkinson, John Hart, Abraham Clark. From New Hampshire, Josiah Bartlett, William Whipple, Matthew Thornton. From Massachusetts Bay, Samuel Adams, John Adams, Robert Treat Payne, Elbridge Gerry. From Connecticut, Roger Sherman, Samuel Harrington, William Williams, Oliver Wolcott. And from Rhode Island, Stephen Hopkins and William Ellery. That is the Declaration of Independence. I'm going to turn my light on. It's getting kind of dark in here. So that was the Declaration of Independence, and now I'm going to read the Constitution of the United States. September 17th, 1787. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be apportioned among the several states which may be included within this Union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue rights of election to fill such vacancies. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. Shush! Section 3. The Senate of the United States shall be composed of 2 senators from each state. I said shush! Sorry. Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year, and if vacancies happen by resignation or otherwise, during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. No person shall be. Ella Light Bear, happy 4th of July to you as well. Hope you're having a good day today. No person shall be a senator who shall not have attained to the age of 30 years, and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers, and also a President pro tempore, in the absence of the Vice President, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except such as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day. Section 5. Each House shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner and under such penalties as each House may provide. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and, with the concurrence of 2/3, expel a member. Each House shall keep a journal of its proceedings, and from time to time publish the same, excepting such parties as may in their judgment require secrecy, and the yeas and nays of the members of either House or any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither House during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. Section 6. The senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during some time, and no person holding any office under the United States shall be a member of either house during his continuance in office. Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it with his objections to that House in which it shall have originated, who shall enter the objections at large on their journal and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of that House, it shall become a law. But in all such cases, the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or be disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States, to regulate commerce with foreign nations, and among the several states and with the Indian tribes, to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States, to coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures, to provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices and post roads, to promote the progress of science and useful arts by securing for limited time to authors and inventors the exclusive right to their respective writings and discoveries, to constitute the tribunals inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas, and offenses against the law of nations, to declare war, grant letters of marque and reprisal, and make rules concerning captures on the land and water, to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress, to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may by session or of particular states, and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all powers vested by this Constitution in the government of the United States, or in any department or office thereof. Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, so basically 1808, but a tax on duty may be imposed on such importation not exceeding $10 for each person. The privilege of the right of habeas corpus shall not be suspended, unless when, in cases of rebellion or invasion, the public safety may require it. No bill of attainder or ex post facto law shall be passed. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept any kind of present, emolument, office, or title of any kind whatsoever from any king, prince, or foreign state. Section 10. No state shall enter into a treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title or of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the treaty of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war, unless actually invaded or in such imminent danger as will not admit of delay. Article 2, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with Vice President, chosen from the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct, a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves, and they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be the majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President, and if no person have a majority, then from the 5 highest on the list, then the said House shall in like manner choose the President. But in choosing the President, the votes shall be taken by states, the representation from each state having 1 vote. The quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident in the United States. In case of the removal from the President from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may by law provide for case of removal, death, resignation, or inability, both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until the disability be removed or a President shall be elected. The President shall at stated times receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. Quote, I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Yeah, some people nowadays wouldn't believe that, if I'm being honest, but anyway. Section 2. Happy 4th, playing that police simulator, then later that made me last. Hey, Chris Clark, how you doing today? First off, happy 4th of July to you as well. And number 2, I will be playing Police Simulator later tonight with viewers like last night. In case anybody wants to join me on there tonight, as well as someone did last night. I know who he is. I know who it is, but I'm just saying. Anyway, Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subjects relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, which shall be established by law, but the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Section 3. He shall from time to time give the Congress information of the State of the Union and recommend their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Now, I just want to stop here for a second. So, you guys have just heard me read what is essentially the powers for the President. Okay? Like, what the President can, how the role of the President. And you guys just heard me read about impeachment. Tell me, where in this Constitution, because due to the Supreme Court ruling, I have to ask this question. You heard me read the section that talks about the president and his role in the country. You literally just heard me read about the impeachment. Can anybody tell me where in the Constitution it says he has presidential immunity in any way, shape, or form? You heard me read that Congress had immunity, but I did not read anywhere. I don't recall reading anywhere where the president has any form of immunity. So yeah, in my book, and I'm saying this right now, in my book, the Supreme Court on the first, like when they made that ruling on that Donald Trump case, they basically picked because of the party line ruling, because it was like 6-3. They basically said, we're choosing our party over the very Constitution we swore we would uphold. Article 3, Section 1. Oh yeah, by the way, if I recall correctly, I'm pretty sure the Constitution was written to keep us as far away from anything remotely similar to a monarchy as we could possibly get. I'm pretty sure that was the point of the Constitution as well, anyway. Right? I thought that was the whole point of the Constitution, but I guess I was wrong there. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Section 2. The judicial powers shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof, and foreign states, citizens or subjects. In all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall be should have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Section 3. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Section 4, Article 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime. Yeah, this was, if I didn't say it, this is section 2 that I'm reading right now. I read the first part. The citizens of each state shall be entitled, blah, blah, blah. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to from the state having jurisdiction of the crime. No person held to service or labor in one state under the laws thereof, escaping into any another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Section 3. New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states, or parts of states, without the consent of the legislatures of the states concerned as well as of the Congress. The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. Section 4. The United States shall guarantee to every state in this Union a republican form of government. It shall protect each of them against invasion, and on application of legislature or of the executive, when the legislature cannot be convened, against domestic violence. Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes, as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several states' legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Article 7. The ratification of the conventions of the 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. The word "the" being interlined between the 7th and 8th lines of the first page, the word 30 being partly written on the erasure in the 15th line of the first page, the words "is tried" being interlined between the 32nd and 33rd lines of the first page, and the word the being interlined between the 43rd and 44th lines of the second page. Attest William Jackson, Secretary. Done in convention by the unanimous consent of the states present in the 17th day of September in the year of our Lord 1787, and of the independence of the United States of America the the 12th in witness that whereof we have hereunto subscribed our names. George Washington, President and Deputy from Virginia. From Delaware, George Reed, Gunning Bedford Jun, John Dickinson, Richard Bassett, Jacob Broom. From Maryland, James McHenry, Daniel of St. Thomas Jennifer, Daniel Carroll. From Virginia, John Blair, James Madison Jr. From North Carolina, William Blount, Richard Dobbs Spate, Hugh Williamson. From South Carolina, John Rutledge, Charles Coatsworth Pinckney, Charles Pinckney, Pierce Butler. From Georgia, William Few, Abraham Baldwin. From New Hampshire, John Langdon, Nicholas Gilman. From Massachusetts, Nathaniel Gorbaum, Rufus King. From Connecticut, William Samuel Johnson, Roger Sherman. From New York, Alexander Hamilton. From New Jersey, William Livingston, David Brearley, William Patterson, and Jonathan Dayton. From Pennsylvania, Benjamin Franklin, Thomas Mifflin, Robert Morris, George Clymer, Thomas Fitzsimmons, Jared Ingersoll, James Wilson, Galvanier Morris. And there you go. Now, the amendments. I'm going to read the amendments and I'm going to try to explain them to everybody here. So this is how it is, alright? The Bill of Rights. Note, the first 10 amendments to the Constitution were ratified December 15, 1791, and form what is known as the Bill of Rights. These amendments were transcribed in their original form. The capitalization and punctuation in this version is on the enrolled original of the 1789 Joint Resolution of Congress proposing the Bill of Rights. Amendment 1. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievances. Basically, it's giving us our basic rights. That is pretty much what it's doing. It's pretty much giving us the rights, the freedom of speech, press, religion, things and such of that nature. It's giving us our basic rights. And freedom of assembly as well on top of that. Now, we're going from a very basic amendment to what is regarded as the most controversial, if not the most, one of the more misunderstood ones, I believe. Amendment 2. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, here's where the problem lies with this. It says a well-regulated militia. That would basically be, well, a well-regulated militia being necessary to the security of a free state. To me, the security of the free state means you're defending it. Self-defense, mind you. Yeah, in my book, this amendment is basically saying you have a right to bear arms as long as you are defending something. But it specifically says that as long as you are defending your state. But I feel like it would be okay with that if you were defending yourself, your family, your property, etc., etc. In my book, that's what it should mean. Anybody that is using a weapon, that is bearing arms to incite fear over self-defense, over defending something, to me, that is not what the Second Amendment is all about. But people keep looking at the Second Amendment, the end of it, how it says the right of the people to keep and bear arms shall not be infringed. They keep looking at that end, but they never really focus on the beginning. And when they do, they have something to explain why. But in actuality, I think what I said pretty much sums it up. Amendment 3. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. The Third Amendment was made because the British had a tendency to barge into people. To my recollection, and I could be wrong here, but they made it to where they would barge into people's homes, and they would have the homeowners, treat them like guests, even though they barged in like intruders. Yeah. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Basically, it's keeping people from being searched for no reason. So the only way you could search people is if you have a warrant for their search, unless like they're in public, and you can search them, because if they were called upon and it was reported to the police that they were doing something and it was out in public, then they can search the person because they have the right to do so, because somebody called about that person. So there you go. But otherwise, generally, if you have no reason to search somebody, that is violating their Fourth Amendment rights. Their Fourth Amendment right. Amendment 5. The one where people like to say, the one where the saying, "I plead the Fifth" comes from. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. It's basically what plead the Fifth means. Basically, you don't have to answer a question if it will incriminate you. Alternatively, they can also say, "I refuse to answer the question on the grounds that it may incriminate me." That is also pleading the Fifth. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So this is the right to a speedy and fair trial, which Donald Trump actually did get in New York. And I know people are going to be like, "Why do you keep bringing Donald Trump in this?" Because some of these things are relevant to him, and it was more recent. That's why I'm bringing these up. But with Trump, he was saying how the trial was rigged, but if you notice, the judge made it to where they would not have the jury be filled with people, with anybody, that the judge would not allow the jury to have anybody that did not really like Trump whatsoever. They were trying to find people that were impartial to Trump. Basically, where they didn't like him, but they didn't hate him either. They were just in the middle of them. They just don't care, whatever. That's pretty much what happened in New York. But Trump, being a little whiny baby, decided to pull that card of it was rigged. Because everything is rigged when he loses. Imagine that. Anyway, Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. Basically, it tells you how much you can sue somebody, pretty much. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Basically, it protects people from cruel and unusual punishments. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Pretty much it's ensuring your rights are well protected in some way, shape, or form. Amendment 10. The powers not delegated by the United States to the United States by the Constitution, nor prohibited by it to the states, are reserved to the state respectively, or to the states respectively, or to the people. Basically talking about states' rights, I'm pretty sure. Now for the rest of the amendments here. Amendment 11. Passed by Congress March 4th, 1794. Ratified February 7th, 1795. Note: Article 3, Section 2 of the Constitution was modified by the 11th Amendment. The judicial power of the United States shall not be construed to extend any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Amendment 12. Passed by Congress December 9th, 1803. Ratified June 18th, 1804. Note: a portion of Article 2, Section 1 of the Constitution was superseded by the 12th Amendment. The electors shall meet in their respective states and vote by ballot for President and Vice President, one of whom, at least, shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as President, and in distinct ballots the person voted for as Vice President, and they shall make distinct lists of all persons voted for as President, and of all persons voted for as Vice President, and of the number of votes for each, which lists they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and votes shall then be counted. The person having the greatest number of votes for President shall be the President, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers not exceeding 3 on the list of those voted for as President, the House of Representatives shall choose immediately by ballot the President. But in choosing the President, the vote shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a President, whenever the right of choice shall devolve upon them before the 4th day of March next following, then the Vice President shall act as President, and in case of the death or other constitutional disability of the President, the person having the greatest number of votes as Vice President shall then be Vice President, if such number be a majority of the whole number of electors appointed, and if no person having the majority, then from the 2 highest numbers on the list, the Senate shall choose the Vice President. The quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of President shall be eligible to that of Vice President of the United States. So, yeah, that's a lot of reading on that one. Amendment 13, passed by Congress January 31st, 1865, ratified December 6th, 1865. Note: a portion of Article 4, Section 2 of the Constitution was superseded by the 13th Amendment. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. Amendment 14. Passed by Congress June 13, 1866. Ratified July 9, 1868. Yeah, that took a long time for that one, didn't it? Note, Article 1, Section 2 of the Constitution was modified by Section 2 of the 14th Amendment. More on that when we get to that. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any persons of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective members, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil and military, under the United States or under any state who, having previously taken an oath, as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid to or comfort to the enemies thereof. The Congress may, by a vote of 2/3 of each house, remove such disability. Section 4. The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume, pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. Amendment 15. Passed by Congress February 26, 1869. Ratified February 3, 1870. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. Amendment 16. Passed by Congress July 2, 1909. Ratified February 3, 1913. Note: Article 1, Section 9 of the Constitution was modified by the 16th Amendment. The Congress shall have power to lay and collect taxes on income from whatever source derived, without appointment and among the several states, and without regard to any census or enumeration. Article 17. Passed of... You were doing so well, Bear. Shush. Amendment 17. Passed by Congress May 13, 1912. ratified April 8, 1913. Note: Article 1, Section 3 of the Constitution was modified by the 17th Amendment. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue rights of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the power fill their vacancies by the election and as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. Excuse me. Amendment 18, passed by Congress December 18, 1917, ratified January 16, 1919. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States in all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2. The Congress in the several states shall have conferred power to enforce this article by appropriate legislation. So that was that amendment up until a certain other amendment. Now we'll get into later. Was started what was known as the Prohibition era, where people were basically bootlegging. They were making any kind of alcohol, whatever kind of alcohol you can think of that is served in the United States, they pretty much made. Yeah, whiskey, like any kind of alcohol, liquor, whatever. They made it. It was completely bootlegged because it was all completely illegal. And yeah, so that was a hell of a time for people back then. And not in a good way, most likely. But anyway, continuing on with the article, with the amendment. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. Amendment 19, passed by Congress June 4th, 1919, ratified August 18th, 1920. The rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. Amendment 20, passed by Congress March 2nd, 1932, ratified January 23rd, 1933. Note: Article 1, Section 4 of the Constitution was modified by Section 2 of this amendment. In addition, a portion of the 12th Amendment was superseded by Section 3. Section 1. The terms of the President and the Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the third day of January of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin. Section 2. The Congress shall assemble at least once in every year, and such meetings shall begin at noon on the third day of January, unless they shall by law appoint a different day. Section 3. If, at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified, and the Congress may by law provide for the case wherein neither the President-elect nor Vice President-elect shall have qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, if such person shall act accordingly until a President or Vice President shall have qualified. Section 4. The Congress may by law provide for the case of the death of any of the persons from whom the House of Representatives may choose a President whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons from whom the Senate may choose a Vice President whenever the right of choice shall have devolved upon them. Section 5. Sections 1 and 2 shall take effect on the 15th day of October, following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. Amendment 21, passed by Congress February 20th, 1933, ratified December 5th, 1933. Section 1. The 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided in the Constitution within 7 years from the date of the submission hereof to the states by the Congress. Amendment 22, passed by Congress March 21st, 1947, ratified February 27th, 1951. Section 1. No person shall be elected to the office of the President more than twice, and no person who is now, for the record, this amendment, I can already tell you now, this amendment was passed, I'm going to assume mainly because of Franklin D. Roosevelt. Because Franklin D. Roosevelt was serving under not just 2 terms, but he was starting on his 4th term. And he passed away sometime after that. He was on his 4th term when he passed away. Harry Truman took over. And, yeah, so there's that. And this was in part because of that. Anyway, no person shall be elected to the office of the President more than twice, and no person who has held the office of President or acted as President for more than 2 years of a term to which some other person was elected President shall be elected to the office of the President more than once. But this article shall not apply to any person holding the office of President when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of President or acting as President during the term within which this article becomes operative from holding the office of President or acting as President during the remainder of such term. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Library of Congress. Amendment 23, passed by Congress June 16, 1960, ratified March 29, 1961. Section 1. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of President and Vice President equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of President and Vice President to be electors appointed by the state, and they shall meet in the district and perform such duties as provided by the 12th Article of Amendment. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. Amendment 24. Passed by Congress August 27, 1962. Ratified January 23, 1964. Section 1. The right of citizens of the United States to vote in any primary or other election for president or vice president, or for electors for president or vice president, or for senator or representative in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. This was in part because the South had this idea of making it to where they knew they couldn't stop a black person from voting, but they could make it to where a black person could still not be able to vote without telling them they cannot vote. And that was with these literacy tests. Because because slaves in that time, during the days of slavery being legal in the South, one of the rules was that they could not teach the slaves how to read. Slaves were not allowed to be taught how to read. And so so this was their workaround. Well, Congress, had, at this point had some issues with it now, almost 100 years after slaves earned their freedom, as well as the 13th, 14th, and 15th Amendments being the start of that. That was almost 100 years. This was almost 100 years by that point. Yeah. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment 25. Passed by Congress July 6, 1965. Ratified February 10, 1967. Note: Article 2, Section 1 of the Constitution was affected by the 25th Amendment. Section 1. In case of the removal of the President from office or of his death or resignation, the President shall become President. Section 2. Whenever there was a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both Houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the executive department or of such other body, as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. That's a bit of a tongue twister going on right there. Even if you knew what that was saying, that's a bit of a tongue twister going on right there, man. Amendment 26, passed by Congress March 23rd, 1971, ratified July 1st, 1971. Note, Amendment 14, Section 2 of the Constitution was modified by Section 1 of the 26th Amendment. Section 1. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment 27, originally proposed September 25th, 1789, ratified May 7th, 1992. Note, the 27th Amendment was initially ratified by 6 states: Maryland, North Carolina, South Carolina, Delaware, Vermont, and Virginia, and the other 8 states excluded, omitted, rejected, or accepted it. It was ratified by various states over time, and in 1992 was fully ratified as an amendment to the Constitution. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. And there you go. And now they have, and at the very back of the book, they have index to the Constitution and the amendments. And this thing is going from page 74 to page 162. To put it simply, we're not going to read that because then I'll be here all day doing that. So I'm not going to do that. In any event, but yeah, that was the Constitution of the United States and the Declaration of Independence that I just read. Yep, I did raise the question. The Constitution does not mention anything about the Constitution nor the Bill of Rights and the other 17 amendments. Not one of them mentions that a president has any kind of immunity. And you just heard me read it, so I know what I'm saying. So yeah, it doesn't mention anything about the president having any sort of immunity. It does mention the Congress does, but not the president. Or the vice president, for that matter. So yeah. So the way I look at it with what the Supreme Court did, yeah, they picked party over the Constitution, and they should be impeached for that shit. Because when you're gonna when you're gonna put your party over your Constitution that you swore that you would protect and uphold and all that, you don't have the right to call yourself a Supreme Court Justice. You might as well just call yourself a Republican/Democrat Justice if you're going to put your party over the Constitution. That's my take on it. But anyway, with that being said, I hope you guys have a good rest of your 4th of July. I'll be back on later tonight to play some more Police Simulator. But for right now, that's going to be it for me. Hope you guys enjoyed this reading. And until later on tonight, ladies and gentlemen, this is Forrest Walpole, signing off.